Mr. Smith, are you ready?
Your Honor, is the Spanish interpreter available?
Be in just a moment. Ms. Abraham, did you label your device Spanish interpretation computer?
Yes.
That was the interpreter. I don't have an interpreter on Zoom.
So that they were already on. Okay. Well, we'll start with Mr. Blevins then.
Actually, just call somebody else on that way.
Okay.
Can I do them all at the same time? Thank you.
No, Your Honor.
All right, court calls cause number CR 21-92, State versus Glenn Allen Smith. And I believe today we were set on a motion to revoke, I believe. Is that right?
It's Your Honor.
Okay, and go ahead. I think there's an agreement. Go ahead and announce whatever your announcement is.
Our defense is ready. We've come to an agreement with the state where they're going to withdraw their motion to revoke Mr. Smith's probation. In exchange, they were going to extend his probation for a year. I believe add a $2,000 fine, and he's agreed to go to safety.
Is that correct?
Yes, Your Honor.
Okay. All right, Mr. Smith, raise your right hand. I'm going to place you on the road. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Smith, you heard the agreement that your attorney just read to the court. Is that your understanding of the agreement, what you're asking the court to approve?
Yes, sir.
And has anyone pressured you, forced you, made you feel like you had to make an agreement in this regards to this case today?
Yes, sir.
All right. And Mr. Dahman, you've explained to Mr. Smith the modification to his community supervision, how long safety is, that he'll be waiting on a bed at safety, all those things.
Yes, Your Honor. He's going to be transferred to Kaufman first, then transferred back here. Then so he knows it's going to be quite a wait before he arrives at a safety facility.
Okay, very well. All right, then the court will grant the state's motion to withdraw the motion to revoke. Court will continue Mr. Smith on community supervision. Court will amend his community supervision to include an extended period of 1 year of supervision, and also the inclusion of the substance abuse felony punishment facility, also known as safety. So, Mr. Smith, this is your opportunity to go down and take advantage of the state's rehab program to try to give you the tools to help you cope in your life with this drug issue. Okay. If you come back and you don't apply what you learned down there, you're likely to end up right back here, and the next stop will be prison. You understand?
Yes, sir.
All right. So it's not. Sometimes people say good luck in situations like this. It's not about luck. It's about responsibility, accountability, and doing the work. You understand?
Yes, sir.
So go do your work. Thank you, Mr. Dominic.
Your Honor, Mike's used.
Thank you, sir.
No, Your Honor.
Hey, Mr. Head, how are you, sir?
Good, sir. How are you?
I'm doing well. Let's see here. It's on Mr. Anderson.
Yes, sir.
Looks like the plea papers were made with Mr. Weiner's name. Does that make any difference to you?
Your Honor, it is not on the admonishments. I did strike Mr. Weiner's name and just put my name on those with Mr. Anderson, but either way is fine.
Okay. And Mr. Weiner, he has given counsel to Mr. Anderson throughout the case, a combination with you, is that correct?
That is correct, Your Honor.
Okay. All right, Mr. Anderson, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you, sir. You can lower your hand. Mr. Anderson, you appeared before the court on December 11th of 2018. You pled guilty to possession of a controlled substance, penalty group 2, greater than 400 grams. That is a first degree felony offense. Your punishment was assessed pursuant to a plea agreement that day. And your sentence was assessed at 10 years confinement in the Texas Department of Criminal Justice. That sentence was then suspended and you were placed on community supervision for a period of 5 years. It was during your period of community supervision that the state filed its amended motion to revoke. Do you believe you've had enough time to discuss with your attorney, Mr. Mike Head, the state's motion and the allegations contained in that?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you don't understand?
No, sir.
Do you have any questions for Mr. Head or the court before we go forward?
No, sir.
And are you pleased with the representation that Mr. Head and Mr. Weiner have given you in this case?
Yes, sir.
All right, Mr. Head, have you explained to Mr. Anderson the consequences of his plea today?
I have, Your Honor.
All right, do you believe that he's competent and that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do.
Mr. Anderson, and Mr. Head, let me ask, does Mr. Anderson waive the final reading of the state's motion to vote?
He does, Your Honor. I've gone over the allegations. He does understand those.
Does he intend to plead true to all 7 counts?
Yes, sir, Your Honor.
Okay. All right, Mr. Anderson, then at this time, how do you plead to counts 1 through 7 as alleged in that motion to revoke? Are those counts true or not true? You're indicating that they are true, correct? Okay. All right, Mr. Anderson, are you telling me that each one of those counts is true? Because what is alleged is in fact true. You're not just saying that so you can get a plea agreement. Is that right?
Yeah.
Okay. All right, court will accept the defendant's plea of true to each count as alleged. Mr. Head, any objection to the admission of the defendant's waiver of rights of plea of truth?
No objection, Your Honor.
And it's admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state? No, Your Honor. From the defense?
No, sir, Your Honor.
All right. Based on the evidence from the court and Mr. Anderson's judicial confession, the court finds that Mr. Anderson has violated the terms and conditions of this community supervision. Court will follow the plea agreement today. Court hereby revokes his community supervision, assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice Constitutional Division, orders him to pay the balance of his financial obligations, including his fines, court costs, and restitution. And the court finds that Mr. Anderson is part of the plea agreement and is ordered to pay $3,175 to the probation department on the day of the plea. And Mr. Anderson will be given 101 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Anderson, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. Have you step over to the deputy to be fingerprinted. Good luck to you, sir.
And Your Honor, just for purposes of the record, Mr. Anderson has previously paid our office that $3,175, and we have tendered that to the clerk for the probation department here today.
Thank you, Mr. Bennett. I do appreciate that.
Yes, sir. Thank you, Your Honor.
Good to see you.
Yes, sir. You too.
That's paperwork.
Sorry.
Paperwork.
Oh, I set it over here.
Oh.
Sorry.
That's okay.
Thank you.
Honor, good afternoon.
Hello, Mr. Ashmore. How are you, sir?
Doing excellent, sir. Thank you. Mr. Hartwell, good afternoon. Judge, we're here on Casey Spriggs. CR 21-00371. We had initially set some contested matters. The state and I conferred several times over the last 24-hour cycle. There was a prior request in a pretrial hearing for the production of cellular telephones and the data on those phones, which the district attorney's office, in compliance with 3914 and the Michael Morton Act, searched for, was unable to locate. The sheriff's office has now located. They have not, however, as I understand it, been provided or able to duplicate a copy for defense. So we're asking the court to stay all contested pretrial matters because we're not yet done with discovery. Those other matters do seem premature. I did talk to Mr. Hartwell yesterday. The understanding is there's about 30 days of data on the phones, and they're working to provide an image of that to our office as soon as possible. We have submitted, in response to the court's request from our last hearing with regard to the appointment of Dr. Jeff Wax as a mental health and mitigation expert in this case, a very detailed affidavit in support of the totality of work and the anticipated cost to the Van Zandt County Indigent Defense Fund, and that is before the court. And I believe that request is summarized in the motion, and the supporting affidavit is about $39,000 and change. And we're asking the court to grant that request to appoint Mr. Spriggs, a mental health and mitigation expert, Dr. Jeff Wax, and to allow the state and the defense to have an additional docket call and or evidentiary hearing so that we may get those remaining discovery issues, see where we are, let Dr. Wax get to work. I will be submitting, pending the court's approval of Dr. Wax's appointment, I will be submitting a order. I may have already done it, but an order for some in-person contact visits for Dr. Wax to come here to the Van Zandt County Sheriff's Department to interview and visit with Casey. And if that's not before you, of course, that's premature because you haven't approved that at this time, but that's the request we're asking. I think I've covered everything. Mr. Hartwell, have I missed anything?
I think that's everything, our understanding, Your Honor. As far as the phones is, yes, my understanding is we are expecting about 30 more days. Of course, if anything changes on that, we'll update the board and Mr. Ashton as soon as we hear anything on that.
Okay, all right, the court's going to carry the defendant's motion to suppress forward. We're going to reset that to Thursday, October 26th. Court's going to allow 60 days time for law enforcement to finish the forensic analysis in time for Mr. Ashmore to receive and review. Court has taken the motion for the mitigation expert under advisement. Court is still reviewing that, and court will carry all those other issues forward as well. Court may rule on those issues, the mitigation expert, and things unrelated to the motion to suppress in the forensic analysis prior to the 26th, but we're going to carry the other motions that are filed with regards to suppression analysis to the 26th. At 1:30.
Thank you very much, Your Honor.
Any other issues, Mr. Ashmore?
No, thank you so much, Judge. And if you need to visit with Dr. Wax or have him appear for a telephone conference with the state president, he'll make himself available. He could have been available by Zoom today. He does reside in Houston. But based on the court's prior admonition that a detailed affidavit with sufficient scope of work plus budget plus anticipated full vote, what does this look like for the county? That being said, if the court needs to hear from the doctor, we'll set that up. State can be present. It's titled an ex parte motion, but they've been aware of this since we started the request back earlier this year and no problem with. Unless there's a moment where he might ask the state to jump off the line with regards to what he does. But I think he'll be talking in general terms if the court needs to hear from him about general terms about what he will do and the service he will provide in this case.
All right, I do appreciate that offer, and if I need that, I'll certainly reach out to you.
Yes, sir. May I be excused?
Yes, sir. We'll see y'all back on the 26th.
Okay, thank you. Don't forget that letter. Thank you, Judge.
You're welcome. All right, Mr. Schmidt, are you ready?
Richard Blevins.
All right, this is cause number CR 16397, State versus Richard Blevins, wishing to revoke. Go ahead, Mr. Schmidt.
Judge, we're prepared to enter a plea to the state's motion to revoke. You need the terms, Judge?
Yes, sir. I think that's the only thing I don't have. Yes, sir. Go ahead.
Judge, at this point, the state's recommendation upon a plea of true is that Mr. Blevins' community supervision be revoked, that he be sentenced to 3 years confinement, Texas Department of Criminal Justice Institution Division, or to pay the balance of his financial obligations, which are reflected in the judgment. Judge, right now, the judgment shows 69 days credit towards that sentence. However, I've contacted Mr. Hartwell and Ms. Abney to double check on that number. It is a possibility that he had lost some credit time as a condition previously, but we're trying to confirm that. But other than that, we're ready to proceed.
Do you know how long it's going to take to confirm that?
Your Honor, I spoke to Ms. Abney. She was double checking that number. I haven't heard back whether she was able to confirm or not. But she was double checking that when I spoke to her just a few minutes ago.
So, Mr. Schmidt, you're indicating the credit days may not be right on the judgment.
I'm indicating that there's a possibility that they may be short around 47 days, but I'm uncertain because Mr. Blevins had previously been on a deferred. I don't know that, and I can't see in the probation that any of that prior credit time was eaten up as a condition. So I presume if that's the case, then he should have some additional days. Actually, only want to push this up.
All right, well, let's recall Mr. Blevins back up whenever we know for sure what his credit days are. Otherwise, I sign the judgment and we send him down with it and it's incorrect. It's going to create a lot of work. So let's have a seat and then we'll let Ms. Abney have an opportunity. So you think there should possibly be an additional 47 days?
Give or take a day. Yeah, that's what we think.
Okay, go ahead and have a seat, Mr. Blevins, and let us look through that.
My understanding that you have the OCA interpreter.
Yes, Judge, as we were talking.
We're ready to proceed on Mr. Vasquez as well.
Uh-oh.
Great, thank you, Ms. Phil. Good afternoon. If you'll raise your right hand, I'm going to place you under oath. If you'll go ahead and identify yourself and your license number for the record. Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help me God? All right, this is cause numbers CR 23-28 and 2023-25, State of Texas versus Felix Alejandro Vasquez Diaz. Mr. Diaz, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Schmidt, what's going to be the disposition in the felony case?
Judge, I have a motion to dismiss in my hand from the state on the felony case. And then we're proceeding on the 2023-25 case for plea, which is the DWI. I believe those are the only two file cases he has. He had some other arrests that will be 1245 in the judgment.
Okay. All right, Mr. Diaz. Are you a United States citizen who reads, writes, and speaks English?
No.
Are you a United States citizen at all? Or a lawful permanent resident?
No.
You are receiving the assistance. Thank you. You are receiving the assistance of a translator today, are you not? And in this case, I need to know, have you ever been diagnosed with any type of mental condition?
No.
And in this case, you're also represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you? Do you feel like you've had enough time to talk with him about all of your cases and that you understand what you're doing here today, everything that you've read and signed? Do you have any questions of Mr. Schmidt or the court before we go forward?
No.
And Mr. Diaz, do you understand that if the court goes forward with the plea agreement today, that it may have consequences regarding your status in the United States? You understand that you may be subject to deportation and removal proceedings and denial of reentry. Do you understand that? Okay. Mr. Schmidt, do you believe Mr. Diaz to be competent today? And if so, have you explained to him his rights as they pertain to this case? And also, have you discussed the possible consequences regarding his immigration status in the United States.
I do believe he is competent. I have spoken with Mr. Diaz on a few occasions with or through interpreters, including today, going over paperwork. I have discussed with him. It's my understanding that and his understanding that he is not a United States citizen and could potentially be deported based on a plea to these cases. I have given him the opportunity to delay this plea today if he so desired to seek counsel with a practicing immigration attorney. He relayed to me that he's comfortable about moving forward and getting it over with. So we're ready to proceed.
Thank you, Mr. Schmidt. Mr. Diaz, you are charged by information with the criminal offense of driving while intoxicated. That is a Class B misdemeanor, and it does have a range of punishment of a maximum not to exceed 180 days confinement in the jail and a fine, a possible fine, which may not exceed $2,000. The plea agreement in your case is that you would plead guilty to that charge. The state would be recommending that you be found guilty today, that you be assessed and punished with 44 days in the county jail. If you're receiving credit for all 44 days of time served, that you would also pay a $100 fine plus $270 court cost, $530 reimbursement fees, and $60 in restitution. The state would be dismissing a felony charge of evading arrest or detention with a vehicle, a misdemeanor charge of evading arrest, a misdemeanor charge of resisting arrest, and a misdemeanor charge of criminal trespass. Is that your understanding of the agreement that you've made with the state? Okay, Mr. Vasquez, I've explained to you the range of punishment. I've explained to you the plea agreement. At this time, how do you plead to driving while intoxicated? Guilty or not guilty? Mr. Diaz, are you pleading guilty to this crime because you are guilty of committing this crime and no one's threatened, force, or pressure you to do this, correct? All right, court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the admission of the stipulation of evidence?
No objection.
All right, court will admit the stipulation of evidence. Is there anything written on your stipulation of evidence, Mr. Schmidt?
No, sir. This is a standardized stipulation of evidence for misdemeanor cases with the information attached.
Okay. I guess my mom was just out of order. Okay, all right, the stipulation is admitted. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your
Anything further from the defense? All right, then based on the court's review of the evidence, the court finds that there is sufficient evidence to convict Mr. Diaz of this offense. The court will follow the plea agreement. The court convicts Felix Alejandro Diaz Vasquez of driving while intoxicated, a Class B misdemeanor. The court assesses his punishment at 44 days confinement in the county jail, issues him credit for time served in the amount of 44 days, orders him to pay a $100 fine, $60 restitution, $270 in court cost, $530 in reimbursement fees. Mr. Diaz, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with a deputy to be fingerprinted. Once you are released, if you are not deported from the United States, then you need to appear at the Van Zandt County Courthouse and pay your fines, restitution, court costs, and reimbursement fees. Do you understand? All right, step over with a deputy. All right, Ms. Bill, I believe that's all we have for you today. Yes, ma'am, you may. Thank you for being with us today. Mr. Manning in there?
Yes, Judge.
Hey, can we make an announcement on Boylan real quick? Just so I can mark it off.
Yes, Judge.
I didn't mean to interrupt you. If you were working with another client. Sorry about that. Court calls number CR 22-88-7 -168 -169 -170 State versus Gerald Robert Boylan. The court had set this matter for a status hearing on Mr. Boylan and his admission to the state hospital for purposes of competency restoration. Court will let the record reflect that Mr. Boylan was admitted to the state hospital on July 18th, 2023. So I'm going to remove him from the docket at this time until I get further notification from the state hospital about his return to competency.
Yes, Judge.
Thank you, Mr. Manning. Sorry about that. The update on Mr. Blevins and his credit time.
Yes, sir. Ms. Abney has provided us with a itemized list of his credit time. We're ready to proceed.
Is that date correct, or are y'all changing?
Based on her date, 69 days on the judgment is correct. And we have no ability to dispute that at this point. So I've spoken with Mr. Blevins. We're ready to proceed as indicated on the judgment.
All right, we're back on the record. Cause number CR 16397, State versus Richard E. Blevins. Mr. Blevins, if you'll raise your right hand, place your oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Lower your hand. Mr. Blevins, I'm showing you your state's motion to revoke document. Indicates that you appeared before the court on August 10th of 2021. You pled guilty to the offense of aggravated assault with a deadly weapon, a second-degree felony. You reached a plea agreement that day. The court followed the plea agreement. The court assessed your punishment, convicted you, assessed your punishment at 10 years confinement in prison, ordered you to pay a $4,000 fine. Court then, on the recommendation of the state, suspended that sentence and placed you on community supervision for 3 years. It was during that period of supervision that the state filed this motion to revoke on May 18th, 2023. And as you see in this document, the state has alleged 8 separate counts of various allegations of violations. Have you had enough time to review that with your attorney, Mr. Schmidt?
Yes, sir.
Do you feel like you've had enough time to talk with him about it, and that you've had all of your legal questions answered, and you understand everything that you've read and signed? So, I'm sorry, obviously bad connection. Did you say yes? Mr. Schmidt, do you believe Mr. Blevins to be competent?
I do.
And did he waive the formal reading of the state's motion to revoke?
We do, Judge.
Does he intend to play true to all 8 counts?
Yes, sir.
All right, Mr. Blevins, at this time, how do you plead to counts 1 through 8 as contained in the motion? Are those counts true or not true?
True.
Are you telling me that all 8 counts are true because in fact they are true? You did commit the allegations confined in there, and that no one's threatened you, forced you, pressured you to play true?
Yes, sir.
All right, the court will accept the defendant's plea of true to all 8 counts. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of true and evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, yeah.
From the defense?
No, sir.
All right, then based on the evidence before the court finds that Richard B. Blevins has violated the terms and conditions of his community supervision. Court will follow the plea agreement today. The court hereby revokes his community supervision, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations. The court does award him 69 days credit towards his sentence for the time that he has previously spent in jail. Mr. Blevins, you hereby remain into the custody of the sheriffs who can carry out the terms and conditions of his sentence. please step over with the deputy. We can
Your Honor, can we have about 5 minutes?
Yes, ma'am.
Your Honor.
Patty, are y'all ready?
Yes, ma'am.
Okay, I'll let him know.
Mr. Manning, are you ready?
Judge, we're ready here on Mr. Marcus Turner.
All right, what are we doing on Mr. Turner?
Judge, that is going to be a plea. And upon a plea of guilty, punishment to be agreed to be assessed at 10 years TDCJ, probated for 4 years, fine of $500. And they're going to take into consideration unfiled DA case number 2020-0922. Additionally, there will be $500 fines, $209 court cost, and reimbursement in the amount of $570.
What kind of case is 2020-922?
It's also an evading arrest, but without a vehicle.
Any special conditions of community supervision?
No, Judge, we are, because of Mr. Turner's physical situation, we are requesting a little bit of grace with him getting started up on his financial payments. He has an appointment to go to Parkland Hospital as soon as he gets out of here. And so he doesn't know what that's going to result in, if it's going to result in immediate emergency surgery or if it's going to be a longer process. And so I spoke to probation about that, and they've explained their tolerance levels. I've conveyed that to Mr. Turner as well.
Great, thank you, Mr. Manning. All right, Mr. Turner, you'll just raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. Lower your hand. Your name is Marcus Darnell Turner, is that correct? Mr. Turner, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
Mr. Manning, this is not a motion for vote, correct? Is this a new plea?
This is a straight plea for one. Yes, Judge.
And Mr. Turner, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you? Do you feel like you've had enough time to talk with him about your cases and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Turner to be competent? And if so, have you explained to him his rights as they pertain to this case?
He is competent. I've explained to him his rights and he's waiving his rights knowingly and voluntarily.
Thank you, Mr. Rainey. All right, Mr. Turner, you are charged by indictment with the third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison. You've heard the plea agreement today. I'll recite that at this time. State's recommending that upon your plea of guilty, that the court assess your punishment at 10 years in prison, but they're recommending that that sentence be suspended. You be placed on probation, community supervision for 4 years with a fine, court costs, reimbursement fees, as Mr. Manning stated. They would be dismissing your misdemeanor evading arrest charge. Is that your understanding of the plea agreement and what you want the court to approve?
Yes, sir.
All right. All right, Mr. Turner, understanding the range of punishment and the plea agreement, how do you plead to evading arrest or detention with a vehicle?
Yes.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to state's one as offered.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Never defense judge.
Mr. Manning, if you could read the stipulation for me, I don't have paper.
Yes, Judge. On or about April 30th, 2022 in Van Dyke County, I, Marcus Darnell Turner, was driving in Wills Point when Officer Bocook attempted to make a lawful stop. I saw Officer Bocook activate his emergency sirens and lights in his marked police cruiser, but I failed to stop. Continued to driving until I abandoned my vehicle and eluded the police to be arrested later on a warrant.
Mr. Manning, Ms. Grisham says that if you ever read that fast again, she's going to commit a crime on you. That's what she just said. All right, thank you. Court, based on the evidence, finds that there is sufficient evidence to convict Mr. Turner of this offense. The court will follow the plea agreement today. Court convicts Marcus Darnell Turner of evading arrest with detention with a vehicle. Court assesses his punishment at 10 years confinement in Texas Department of Criminal Justice. Court suspends that sentence, places him on community supervision for 4 years, orders him to pay a $500 fine, $290 court cost, $570 in reimbursement fees. The court dismisses under section 1245, cost number 2020-0922 in evading arrest. Mr. Turner, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Please go over and see the deputy to be fingerprinted and then talk with the probation officers about the next step. Okay. All right, who's next?
Judge, we have Mr. Chandler Chaffee.
All right, CR 22-4.
Judge, we're also, oh, sorry.
I was gonna say, I do have some paperwork here. Go ahead, tell me what you're gonna say.
Judge, we also have CR 23-155, a misdemeanor, which was filed by information, I believe, earlier this week. And we'll be resolving both of those cases today.
All right, so it looks like in CR 22-4, the state's gonna ask the court to withdraw its motion to adjudicate to continue him on community supervision with 168 days in jail as a condition, reimbursement fees for the attorney fees, and then in the new case, which is a class A misdemeanor assault, causes bodily injury of a family member. The recommendation is upon a plea of guilty, 28 days confinement in the county jail, credit for the 28 days of time served, $100 family violence fine plus court costs and reimbursement fees. Is that right, Mr. Manning?
That is correct, Judge.
All right, Mr. Chaffee, raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. All right, Mr. Chaffee. As to cause number CR 23-155, you are charged with assault causes bodily injury a family member. In this case, you're represented by your attorney, Mr. Manning. You feel like you've had enough time to talk to Mr. Manning about your case and have all your legal questions answered?
Yes, sir, I did.
Is there anything about the paperwork regarding either one of your cases that you do not understand?
No.
You heard me read the plea agreement in court. Is that your understanding of the plea agreement in each case?
Yes, sir.
The Class A misdemeanor offense carries a range of punishment of not less than 0 days and not more than 365 days confinement in the county jail and a possible fine not to exceed $4,000. So understanding the plea agreement and understanding the range of punishment, Mr. Chaffee, how do you plead to that offense?
Plead guilty.
Are you pleading guilty because you are guilty of committing that offense? Someone's threatened you, forced you, or pressured you to do that?
I plead guilty because I am guilty.
No one's pressured you or
No.
made you had to do that, correct?
No, sir.
Mr. Manning, do you believe Mr. Chaffee to be competent to enter into that plea and that he's doing that intentionally, knowingly, and voluntarily?
I do, Judge. We had an opportunity to review and discuss the discovery on this case, even though it was just recently filed. We explored possible defenses in that case, and he was able to participate in that discussion with me. So I do believe he is aware of the charge against him, the nature of the charge and punishment, and is able to plead guilty in this case, freely, knowingly, and voluntarily.
All right, so Mr. Manning, do you have any objection to the admission of the stipulation of evidence to support the plea?
Judge, I did not see attached in our paperwork a stipulation of evidence. As it was a misdemeanor, I didn't know if they were just gonna take his verbal and written admissions as the stipulation. But there is not a stipulation of evidence that was attached in our paperwork.
Okay, so you can disregard my questions. All right, Mr. Chaffee, with regards to your felony probation, tell me why I should follow either one of these recommendations and put you back on probation. Why should I do that?
Well, sir, I mean, I believe everybody deserves a second chance. And 8 years deferred was a lot for me to, and I just ask you to, give me a second chance and promise you I'll do right. I won't fail no more UAs or nothing. I don't know what I was thinking that I could get away with drinking a little bit or I had a lot of other stuff going on and I forgot to pay a couple fines and but that's all I have to say, sir.
And Judge, if I may, we've been in contact with the probation department and they are unopposed to this particular resolution. Just understanding that Mr. Chaffee is on the mental health case with Mr. Jarvis Crawford.
All right. And Mr. Chaffee, you understand what kind of prison sentence is looming in your future if you violate this condition, any of these conditions of this probation. You understand that?
Yes, sir, I understand.
You understand if I grant you this second chance, as you call it today, there's no guarantee that you'll be given any other chances after today.
Yes, I understand.
All right, and is the victim in the assault case, are they in agreement or opposed or silent on this agreement?
Your Honor, due to the recency of this case, our office has not had a chance to reach out and choose the victim. So I could not give the court an intelligent answer to the victim's support of this. The date of offense on the assault family violence is June 22nd of this year, Your Honor.
Can you tell me about the nature? Just because I don't have any information as to the assault, all I know is it's a Class A misdemeanor. Is it, can one of you tell me who the alleged victim is?
Yes,
Who
Your
the
Honor.
victim is?
Alleged victim is in a dating relationship with Keaton Lloyd, in a dating relationship with Mr. Chaffee. Nature of the assault looks like they got into an argument at the home. And at some point, Mr. Chappie, bit, Miss, Floyd's ear, did not break skin, but did cause pain.
All right. Court, based on the evidence, and Mr. Chaffee's judicial confession, the court hereby convicts Mr. Chaffee of assault causes bodily injury to a family member, assesses his punishment at 28 days confinement in the county jail, awards him 28 days credit towards that sentence, orders him to pay a $100 family violence fine, $270 court cost, and $15 reimbursement fees. Court also grants the state's motion to withdraw the motion to adjudicate. Court will enter new conditions of 168 days confinement in county jail from the periods of November 12th, 2021 to April 28th, 2022, as a condition of community supervision, to which if Mr. Chaffee is revoked, he will not receive additional credit for that time towards any sentence. The court will order him as a amended conditions of community supervision to pay a $500 attorney reimbursement fee to Mainzane County. So Mr. Chaffee, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Have you step over with a deputy to be fingerprinted on the assault charge, and then talk to the probation officers about the next step. All right, this is Mr. Delbert. This is cause number, CR 20-380. State versus Joshua Scott Delbert on motion to. Go ahead, Mr. Kane.
Yes, Judge. The state has agreed to withdraw and continue him on probation. As part of that agreement, the agreement was reached that 131 days of his time in the county jail will be eaten up as a condition of that probation, and those dates are listed on the paperwork. There was also a inclusion of an amendment to the conditions of probation to update the court cost, fines, and attorney's fees, as well as reflecting the period of community supervision for confinement. That 131 days credit is listed on there as well.
Any extension?
No, Judge.
Okay. And what are the new costs?
I'm sorry, Judge.
How much are the new costs?
The new costs listed are court costs amount of $360, fine in the amount of $4,000, court appointed attorney's fees in the amount of $1,250 for a total of $5,610 with a rate of $205 per month. First payment to be made September of 23.
And so a lot of these costs he already had as his condition. What were the new costs, the new court cost of what is it itemized like that? If it's not, it's make sure.
It just gives a summary.
All right, Mr. Delbert, raise your right hand, sir. Do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Delbert, you understand that the plea agreement, as Mr. Manning has stated,
Yes, sir.
and the state's willing to withdraw their motion. However, the 131 days that you've done in jail, if you are later revoked and sentenced to prison, you're not going to get credit for that time. You understand that?
Yes, sir.
You understand that you're going to have new costs associated with attorney fees and court costs added into this probation. Is that correct?
Yes, sir.
And has anyone threatened, forced, pressured you to make this agreement today?
No.
All right. So tell me why I should allow them to withdraw their motion and reject that.
Because I mean, I've got a good job. I was doing good. I just made a bad choice. You know, other than that, I know I can get it right.
You understand the next time there's not going to be a withdrawal of the motion. The state's going to have to go forward, and I'm going to hear the evidence. If I find that you are continuing to violate the probation, I'm going to have no really choice but to revoke you and take you out of society and put you in prison. You understand that?
I understand that.
All right. All right, court grants the state's motion to withdraw the motion to revoke. Court will continue Mr. Delbert on community supervision. Court orders that Mr. Delbert serve 130 days in jail as a condition of his community supervision. We'll give him credit for that 131 days of time served towards that condition. The court will add additional court costs and attorney fee reimbursements as indicated in the court's judgment and paperwork today. All right, Mr. Delbert, just go talk to the probation officers about what to do when you get out of jail.
Yes, sir. Thank you.
Dobbins, our last one.
Yes, Judge.
All right, Randy Lee Dobbins, CR 2158. All right, Mr. Dobbins, if you'll raise your right hand, place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Lower your hand, make sure you speak up loudly and clearly for me. Mr. Dobbins, you appeared before the court last on October 26th of 2021. You pled guilty to the third-degree felony offense in possession of a controlled substance, penalty group 1. Court heard the evidence, found that there was enough evidence to convict you, but the court followed a plea agreement that day. The court deferred the finding of guilt, did not convict you, but rather placed you on probation for 4 years, and the court assessed a $3,500 fine. During your probation on May 9th, 2023, the state filed its motion to adjudicate, and it has alleged multiple counts, 10 counts to be exact, of various violations. Have you had enough time to review that motion to adjudicate with your attorney, Mr. Jonathan Manning?
Yes, sir.
And are you pleased with the representation that Mr. Manning has given you?
Yes, sir.
Is there anything about the paperwork that you've read over today and that you signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Dobbins to be competent and that he is intentionally, knowingly, and voluntarily entering into this agreement?
That he is competent and he is understanding of what's required of him in this agreement.
And does Mr. Dobbins waive the formal reading of the state's second amended motion?
He does, Judge.
To be true to all 10 counts.
I believe he is going to be true to all 10 counts. Yes, Judge.
All right, Mr. Dobbins, and at this time, I would ask you, well, let me kind of read what the plea agreement is to make sure we're in agreement. You're going to plead true to all 10 counts. The state's recommending that you be convicted today of possession of a controlled substance, a third-degree felony. That the court assess your punishment today at 10 years in prison, but that the court suspend that sentence and place you back on probation under a straight probation for 4 years. And that as a condition of your community supervision, that you attend the drug rehab known as safety. You would have your fine, you would have your original fine, restitution, additional reimbursement fees and court costs. Is that what you're wanting to do today, Mr. Dobbins? Okay. All right, then understanding of the plea agreements, I would ask you at this time, how do you plead to all counts of the state's motion? Are those counts true or not true?
True.
Are you telling me that all 10 counts are true because in fact, what is alleged is true? You're not just saying that so you can get out of jail and get into a rehab program, correct? You had to say out loud so she can write it down.
True.
Okay. All right, and Mr. Dobbins, or Mr. Manning, let me ask, is there any objection to the admission of the defendant's waiver of rights to plead true and evidence?
No objection, Judge.
All right, that is admitted and the court takes judicial notice of Mr. Dobbins' judicial position. Anything further from the state?
No, Your
From the defense?
And then for defense, Judge.
All right, Mr. Dobbins, let me ask a couple of questions through this. So you understand that, maybe you don't understand, but you're going to understand that Safety is a drug rehab run by the Texas Department of Criminal Justice. And it's limited. It's not just a wide open facility. It's a lockdown facility. And the purpose of that is not to incarcerate somebody and keep them locked up from society, but rather to take someone who has a drug problem, give them tools and education on how to come back to society, operate in society, cope with their addictions, and be a productive member of society. There's only certain people that are going to be successful at safety. And those people are the ones that go down there with an open mind, an open heart. They acknowledge that they have a drug problem. They're tired of having a drug problem. They know that they may have this addiction the rest of their life, and they actually want help to get their life back on track. Those are the only people that make it. I need to know, are you that kind of person?
Yes, sir.
So if I tell TDC, Randy's coming down, we think he's a good candidate, he's gonna take advantage of these things, you're not gonna get down there and quit, cause a problem, or disregard what's going on down there. You're actually gonna go down there and apply yourself and try to come back a better man than you showed up.
Good.
All right. I'm gonna take you at your word. All right, the court, based on the evidence, finds that Randy Lee Dobbins has violated the terms and conditions of his community supervision. The court will follow a plea agreement today. The court convicts him of possession of a controlled substance, penalty group 1, greater than 1 gram, less than 4 grams. Court assesses his punishment today for that crime at 10 years confinement in the Texas Department of Criminal Justice. Court finds that it would be in the best interest of the defendant society for him to have that sentence suspended, and he is placed on community supervision for 4 years. And he is ordered to pay the balance of his financial obligations, including additional court costs and additional reimbursement fees in addition to the original fines. The court also has a special condition of community supervision, orders him to attend the substance abuse felony punishment facility. All right, Mr. Dobbins. Once you get down there, man, go to work, make yourself better, get back out here. So I know that the last time we did that, or one of the times we've met, you told me you had CPS in your life, you got a new baby or a toddler or something, right?
Yes, sir.
All right, and it's I thought you said it was a little boy, right?
Yes, sir.
How old is he now?
9 months.
9 months. Okay. The good news and the bad news is this, all right, and I'll go with the bad news. All right. So the bad news is that at 9 months old, he's going to be a completely different kid when you see him next. All right. There's so much that occurs between 9 months and 18 months, 2 years old. They grow up so quick. That's the bad news. You're going to miss a lot of that. Okay. Here's the good news. He's not going to know you're not there. Okay. So the good news is even though you're missing that, you can see that in photos, videos, all those things, but he's not going to know you're not there. So if you want to be a real father, a real man, be in this life, then you're going to come back. You're going to have the tools to stay out of prison, to stay out of jail, and be there for the rest of that kid's life without him knowing. Okay. So take the bad news, take the good news, reconcile both of those together, do what you got to do, come out and do what you say you're going to do. Okay. All right, Mr. Dobbins, let's go over and see the deputy. He's going to take the fingerprints. Mr. Manning, anyone else?
Judge, I believe that concludes my business.
All right, thank you, sir. Appreciate your work today. And Ms. Taberham, do we have anybody else in jail or extraditions or anything that we can help them with?
Wait, we still have one more. We have Bass.
We have,
Mr. Bass on, Jake Wheeler.
no, that's right. I see it right here.
Okay, good afternoon, Judge.
Mr. Bass, I tried to shut down shop on you. Tried to get out of here before calling your things and they was.
Got started a little late this morning, Judge. I was in Fort Bend County and got hung up there a little later than I thought it would be. But anyway, I got on the road as soon as I could.
Okay.
There is a little problem with the paperwork and also I did speak to the prosecutor's office on the jail credit a few times today. But Mr. Wheeler's he's got a few more questions about it. And so probably he's not wanting to sign at this time, but we maybe get one more setting, non-trial setting, and see if I can get that straightened out, visit with him a little bit more. and try to get an agreement on it.
Yeah, I can entertain that, but on the jail credit, what's the issue? I know that I got communication that current jail credit is like 212 days.
That's right. And Stephanie there in the prosecutor's office is really good at that. He did have some, and she counted some TDC time in there. She counted some Brazoria County time, and of course, here in Van Zandt County. Mr. Wheeler thinks there may be more TDC time that he's entitled to credit, but it may be an issue of whether there was a detainer or a warrant from here. At the time, I think he probably does have some more TDC time that was in that range, but anyway, might need a little bit more investigation.
Okay, state, do you have a position at all? Any objection?
No, Your Honor, I'm, Ms. Happy did talk to me about, there being some issue about, tracking down all the time. We want to make sure that we get Mr. Wheeler,
And also the 6 that's on the paperwork, state did agree to make that 5, for sure. But, anyway, so that's another issue right there.
What was, I didn't catch that. You said make something a 5?
6 TDC on the paperwork I have today. That was the offer prior to some discussions I had with Ms. Curry the last time, and the last offer was 5 on it. So that need to be corrected.
I'll let y'all take that up and talk through those issues. All right, so Mr. Bass, next setting that I have will be September 19th. Be the next available criminal docket. You want to do it on that day? I got the 19th or the 21st or the 26th.
26 would be real good for me, Judge. 26. September 26.
All right, court will set Mr. Wheeler then to nurse plea on Tuesday, September 26th at 1:30.
1:30, great. Okay, thank you very much.
Yes, sir. Dave, anyone else?
No, Your Honor, I believe that concludes our business.
Thank you, ma'am. Tell Martinez I appreciate his work.
We'll see you in a few minutes.